Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the Trump administration's continued use of our military on the war-torn streets of the United States. As you all are aware, the number of Army National Guard troops in Washington, D.C. in the last week has appeared to increase to above 2,000 soldiers. The following states, led by Republican governors, deployed troops ranging from around 135 to 400 guardsmen per state. The states who provided troops to support the Trump administration's authoritarian D.C. takeover so far are South Carolina, West Virginia, Ohio, Louisiana, Mississippi, and Tennessee. Don't be surprised if Florida Governor Ron DeSantis piles another 5,000 Guard soldiers into D.C. next week to help secure the Shake Shack at Union Station. While we wait on the litigation and appeals out of California and Washington, D.C. to conclude regarding the deployment of Guardsmen and active duty U.S. Marines in L.A. and Guardsmen in D.C., I want to discuss some relevant law related to the government's authority to deploy the U.S. military domestically within the United States. In the U.S., our laws and traditions since the founding have generally frowned upon domestic use of the military because militaries of the European monarchies, including the British Crown, that once governed the U.S. territory, and other pre-revolutionary societies had previously oppressed their citizenry with their militaries. American law generally leaves limited circumstances where domestic troop deployment is lawful. Those scenarios generally include quelling insurrection, repelling hostile foreign military invasions, and provide assistance in natural disasters, like you see with hurricanes, wildfires, and other matters. In an early example of the limitation of domestic use of the military, the Third Amendment of the U.S. Constitution states, quote, "No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." The founders thought it was so important to include the Third Amendment in this circumstance to protect private property rights from potential abuse by government troops, as people had experienced from the British military in the colonies, where private property owners often had little recourse against live-in government squatters. Excuse me. A federal law that generally prohibits domestic deployment of active duty troops in the United States is known as the Posse Comitatus Act. The federal law 18 United States Code Section 1385, caption Use of Army, Navy, Marine Corps, Air Force, and Space Force as Posse Comitatus states, quote, "Whoever, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army, the Navy, the Marine Corps, the Air Force, or the Space Force as a posse comitatus or otherwise to execute the laws shall be fined under this title or imprisoned not more than 2 years or both." By the way, the term posse comitatus, as you can imagine, is a Latin term directly translating into, quote, "the power of the county," which references a group of citizens summoned by a sheriff or other law enforcement officer to help keep the peace, make arrests, or apprehend criminals. In regards to potential insurrections, 10 United States Code Section 251 provides congressional authority to the president as follows, quote, "Wherever there is an insurrection in any state against its government, the president may, upon the request of its legislature or of its governor, if the legislature cannot be convened, call into federal service such of the militia of the other states in the number requested by that state and use such of the armed forces as he considers necessary to suppress the insurrection. I have to say, I have not seen a single state request President Trump send in the National Guard to quell insurrection. I also haven't seen any insurrections occurring. How an insurrection is defined is a key piece of the pending litigation. One of the statutes in the LA case that we covered in episode 34, 10 United States Code, section 12406, titled National Guard in Federal Service, states, quote, whenever, 1, the United States or any commonwealths or possessions is invaded or is in danger of invasion by a foreign nation, 2, there is a rebellion or danger of a rebellion against the authority of the government of the United States, or 3, the President is unable with the regular forces to execute the laws of the United States, the President may call into federal service members of the United States, members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders of these purposes shall be issued through the governors of the states, or, in the case of the District of Columbia, through the Commanding General of the National Guard of the District of Columbia. One of the central legal disputes in the case and likely appeals to follow centers around whether or not President Trump's deployment of troops was lawful pursuant to subsection 3, because they argue the Marines and Guard soldiers were deployed because government actors who incited protesters were preventing them from executing U.S. immigration law in the form of ICE raids. Judge Charles Breyer of the U.S. District Court of the Northern District of California on June 12, 2025, preliminarily found that the Trump administration's domestic troop deployment to L.A. violated 10 United States Code, section 12406. In that order, Judge Breyer stated, quote, defendants concede that ICE succeeded in arresting 44 people on June 6th, but insist that that limited success came with the risk of danger and that had the protests not interfered with their operations, ICE, quote, would have been able to carry out additional execution of the law's activity. Whether ICE could have detained more people in the absence of the protests is mere conjecture. Defendants provide no support for that assertion. Even assuming that defendants are correct, however, the statute does not allow for the federalizing of the National Guard when the president faces obstacles that cause him to underperform in executing the laws. The statute requires that the president be unable to execute the laws of the United States. That did not happen here. A classic example of a president being unable with the regular forces to execute the laws, indeed the only time in this country's history that a president has exclusively relied on section 12406 to federalize the National Guard, is the 1970 Postal Service strike. On March 23, 1970, President Nixon declared a state of national emergency, ordering 25,000 personnel from the National Guard and other military branches into New York City to, quote, get some mail moving. In that case, the mail system was incapacitated. The regular forces of letter carriers were on strike, and there was no other way to deliver the mail. In this case, the regular forces were and still very much are on duty. While ICE was not able to detain as many people as defendants believe it could have, ICE was nonetheless able to execute the federal immigration laws. Indeed, ICE continues to carry out enforcement actions executing those laws. The U.S. 8th Circuit Court of Appeals, in a case captioned Bissonnette versus Hague in 1985, stated, quote, Civilian rule is basic to our system of government. The use of military forces to seize civilians can expose civilian government to the threat of military rule and the suspension of constitutional liberties. On a lesser scale, military enforcement of the civil law leaves the protection of vital Fourth and Fifth Amendment rights in the hands of persons who are not trained to uphold these rights. It may also chill the exercise of fundamental rights, such as rights to speak freely and to vote, and create the atmosphere of fear and hostility which exists in territories occupied by enemy forces. The interest in limiting military involvement in civilian affairs has a long tradition, beginning with the Declaration of Independence and continued in the Constitution, certain acts of Congress, and decisions of the Supreme Court. The Declaration of Independence states among the grounds for severing ties with Great Britain that the King, quote, has kept among us in times of peace standing armies without consent of our legislature, and has affected to render the military independent of and superior to the civil power. These concerns were later raised at the Constitutional Convention. Luther Martin of Maryland said, quote, when a government wishes to deprive its citizens of freedom and reduce them to slavery, it generally makes use of a standing army. The U.S. Supreme Court, in a case captioned Lard versus Tatum in 1972, stated in reference to this topic on the limitations of the domestic use of the military within the U.S., quote, the concerns of the executive and legislative branches reflect the traditional and strong resistance of Americans to any military intrusion into civilian affairs. That tradition has deep roots in our history. Their philosophical underpinnings explain our traditional insistence on limitations on military operations in peacetime. However, it should be noted that the U.S. 8th Circuit Court of Appeals, in a case captioned United States versus Casper in 1976, the court held that the military assistance given to civilian authorities that is not inclusive of direct involvement in civilian law enforcement is not precluded. This indirect involvement can include things such as providing supplies and training to civilian law enforcement. If you see the military on the streets of your city or town in the future in the coming days, know that members of the military, in most circumstances, do not have the power to replace or supplement the law enforcement duties of civil authorities, which would be your state and local police, law enforcement, and federal agents tasked with federal law enforcement duties. Additionally, ICE generally has no authority to do anything to U.S. citizens. I also recommend that despite the circumstances, you be respectful to any military members you encounter, unless you witness them engaging in unlawful activities, such as unauthorized domestic law enforcement tasks, or of course, if another valid reason warrants disrespect. As a former member of the U.S. military, I can tell you that the vast majority of the military members involved in these matters are simply following orders. When there is a dispute as to whether orders given to the military by a president are lawful, the military JAG, or Judge Advocate General Corps, which serves as basically the military legal system, is supposed to make the right legal calls and direct that unlawful orders be disobeyed. Let's hope that the military JAG Corps abides by whatever final ruling comes out of the court, which hopefully entails a proper application of the clear statutory language of the above-mentioned laws and others. To the members of our military that are involved in these shameful, raw political exercises, only follow lawful orders and always uphold your oath to the U.S. Constitution, first and foremost. Put the U.S. Constitution over any political views that you may have. It is way more important, regardless of whether you like our elected officials or not, in any time, regardless of who's in office. Remember, 10 United States Code, Section 892, which is Article 92 of the Uniform Code of Military Justice, states that only failure to obey lawful orders can result in punishment. You cannot be punished or court-martialed for disobeying unlawful orders. Consult with your chain of commands, JAG team, or speak with a private attorney if you are unsure of whether an order you have received is lawful. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.